Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. If awesome immigration litigator Kate Malloy Goddell is posting about it on social media, it's probably time for me to talk about it on the podcast as well. The Federal Bar Association's Immigration Law section is having its annual Immigration Law Conference in Salt Lake City from Friday, May 10th to Saturday, May 11th. That's coming up pretty soon. There's going to be lots of panels on a wide range of immigration matters, quote, with a robust focus on CLE credit, end quote. I'll be there. Won't you join me? As I've mentioned before, I like FBA immigration because it's pretty much the only conference where government attorneys in the immigration space can also attend. And isn't that just wonderful? I think so. Includes judges. Hope to see you there in Salt Lake City. Speaking of judges, the BIA amended matter of FCS for a second time, the third iteration. I refuse to do it. You win, BIA. Although a quick review that I couldn't help myself from doing, along with a wonderful KKTP intern, informs me that only some slight verbiage in a footnote was changed, I think. You win, BIA. Are you happy? Are you not entertained? Here's to hoping that this is the final version of matter of FCS. And anyway, here's 3 more decisions. Our first case is Bristow v. Mayorkas, published in the Northern District of Illinois on March 28, 2024. It's another case recommended by IRA that I did because, well, it's another short and otherwise rough week for non-citizens. But also to give props to the excellent attorneys on the win. This case is about I-130 denials. Mr. Bristow is a U.S. citizen. His husband, Felix Bristow, is not. He's from the Philippines. They're in a valid marriage, everyone agrees. But USCIS denied Mr. Bristow's I-130 petition filed for Felix Bristow under INA Section 204C. USCIS held that, quote, nearly 2 decades earlier, Felix Bristow had attempted to evade immigration laws by entering a sham marriage with an American woman, end quote. Stay away from me, American woman. I can only imagine was the legal argument made by USCIS. Guess who? Her name was Marilyn. Based on that finding, USCIS denied, as it must. If a non-citizen engaged in marriage fraud for immigration purposes in the past, they can never have a spousal-based I-130 approved for them again in the future. But like the standard to make something a valid marriage isn't forever and always. And yes, I know my T-Swift references are very outdated. Quote, to establish that a marriage is bona fide, a couple must provide primary evidence that shows at the time of the marriage they intended to establish a life together, end quote. What happens later, like divorce, infidelity, even lying, it's only important to the extent that it sheds light on this initial time. What was the intent of the parties at the time of the marriage? And you know we love burdens of proof on the podcast. Quote, in determining that a marriage was fraudulent, the government bears the initial burden of demonstrating through substantial and probative evidence that the marriage was entered to evade immigration laws. End quote. And to get through the legal section, because it's really good in this one, the district court relies on Seventh Circuit precedent to quote the Seventh Circuit and say, quote, a good faith marriage motivated only in part by immigration benefits is not illegal, end quote. What a quote that is, no? And I mean, it makes sense. If you're in a bona fide marriage to a non-citizen, it only makes sense that you and your partner would be thinking about how to resolve your partner's immigration status. Anyway, again, Felix Berto is from the Philippines, and he's obviously now gay. He's in a valid marriage to a man. And Marilyn is a woman, and she filed that I-130 petition pretty soon after they married all those years ago. But they weren't interviewed by USCIS for 2.5 years. During the interview, Marilyn and Felix Berto apparently got some facts wrong about their marriage, or that is to say they didn't testify to exactly the same stuff about their marriage at the interview 2.5 years after they got married. Seems like they were probably separated during the interview, probably a Stokes interview. And they then divorced less than a month after USCIS denied the I-130 petition. A few weeks after the divorce, Felix Berto married another woman, Cecilia. And they were married for a long time. But Cecilia never petitioned for Felix Berto. She did, however, submit a letter on behalf of Felix Berto to support Mr. Bristow's I-130 petition years later, explaining that she, Marilyn, and Felix Berto had all lived together at one point, and that during their marriage, that is, Cecilia and Felix Berto's marriage, Felix Berto had come out as gay. And heck, Felix Berto also has a child from another relationship in the Philippines before he came to the United States. Life and sexual preference is complicated. After Felix Berto's divorce from Cecilia, he married Mr. Bristow, and all of this began. USCIS, as we know, denied the I-130 petition. USCIS hadn't made a 204C finding before with the Maryland I-130. And as the district court notes, some of the perceived discrepancies from the denial way back when actually weren't discrepancies at all. The record didn't show what USCIS was saying it showed. But nevertheless, USCIS this time reached a 204C finding, going back to the Maryland thing and finding it fraudulent all these years later. As such, USCIS denied the I-130 petition filed by Mr. Bristow. USCIS is allowed to do all this. There is no real statute of limitations in the wild, unforgiving world of immigration. Before it denied and made this finding, USCIS issued a notice of intent to deny, annoyed, as it's apt to do. Mr. Bristow and Felix Berto responded comprehensively through counsel, and included, among many other things, a detailed affidavit from Marilyn herself. Among other things, Marilyn said, quote, I am writing this because immigration recently sent notice to Felix Berto about his case that contains false information about what I said to an immigration officer. I want to tell you what really happened, end quote. But USCIS would not be swayed, choosing instead to believe the immigration officer's notes from all those years ago. Notes that almost surely were not turned over to counsel in a FOIA request, but were apparently disclosed during discovery in this federal lawsuit, because that's immigration. Which gets ahead of ourselves a little bit. Mr. Bristow sued under the Administrative Procedures Act. You can still do that and won't run into any jurisdiction stripping provisions or Patel because it's only the challenge to an I-130 petition, not to adjustment of status and all that rough discretionary stuff. Remember it. And even though APA review is deferential, explained the court, quote, the evidence of fraud must be relatively high to trigger Section 204C because the consequence of engaging in marriage fraud is a permanent bar to the approval of any future visa petition. Most of the federal court cases addressing marriage fraud involve direct evidence of fraud, often a sworn statement admitting to the fraud that has not been credibly refuted or rebutted, end quote. Quoting the recent BIA decision in matter of P. Singh for some of that, by the way, and that's an important quote. That standard was unmet to the district court. Although the immigration officer said that Marilyn confessed to fraud way back when, Marilyn strongly contested that in her sworn affidavit. quote, USCIS's denial decision discounts Maryland's declaration as a mere typed statement not under oath. But that statement, in fact, meets all the requirements of 28 U.S.C. section 1746 and thus carries the force of a sworn declaration, end quote. Affidavits are powerful things, folks. Don't forget it. And don't forget it that something becomes an affidavit if it complies exactly with 28 U.S.C. section 1746. Talking to all my clients there who might be annoyed when I come back with edits to their affidavits that include weird language at the end. It's required. Quote, the court is equally uncomfortable with USCIS's apparent heavy reliance on Maryland's original purported statements to officers to meet its burden of showing substantial and probative evidence of fraud, end quote. Burdens matter, folks, even when it's the U.S. government's burden to bear. Quote, USCIS may rely on hearsay evidence only so long as it's probative and its use is not fundamentally unfair, end quote. That wasn't the case here, with purported officer notes of a phone call with Maryland that were directly contradicted by a sworn affidavit later on. Quote, murky at best, end quote, said the court. As was the circumstantial evidence that USCIS also relied upon. All the more problematic because, again, the court believes that USCIS misread some evidence the first time around when it denied Maryland's I-130 petition. Not sure if district courts even have authority to outright grant an I-130 petition, but in this case at least, the court remanded to USCIS for further review. But with strong beliefs about what should happen, in one podcaster's opinion, at least. And of course, big congrats to Brian Green and Michael Jarecki for plaintiffs. Not an easy win to come by. And that is Bristow v. Mayorkas. Moving on to Olmedo Martinez v. Garland, published by the 10th Circuit on April 16th, 2024. Greetings, 10th Circuit. This case is about cancellation of removal and reopening. Mr. Olmedo Martinez is from Mexico and presumably has been in the United States for a long time because in removal proceedings he applied for non-LPR cancellation of removal for non-permanent residence under INA Section 240A-B. In addition to having to show that he's been here for at least 10 years and many other things, he needed to show that his removal would cause extreme and exceptionally unusual hardship to his lawful permanent resident or U.S. citizen spouse, parent, or child. Unsure what he actually argued the first go-around in immigration court, but when an IJ denied on hardship, Mr. Olmedo Martinez moved the BIA for a remand, after of course he appealed it all to the BIA. Apparently at some point, after the IJ ruled, a different IJ granted Mr. Olmedo Martinez's brother withholding of removal due to ongoing familial violence in Mexico. And Mr. Olmedo Martinez's wife gave birth to a daughter. Mr. Olmedo Martinez proffered that all of that was pretty relevant to whether there would be extreme and exceptionally unusual hardship to his U.S. citizen children if he was removed. The BIA did not agree, and so it did not remand. Then, after that became final, I suppose over 30 days later, Mr. Olmedo Martinez moved to reopen everything with the BIA, asserting that, quote, his son's diagnosis with a complex medical condition and an educational impairment, end quote, now made it such that he had established a prima facie case for extreme and exceptionally unusual hardship to his qualifying relatives. The BIA denied that motion to reopen as well. It still didn't see a case. So Mr. Olmedo Martinez petitioned for review to the 10th Circuit. First, as always, though, there's jurisdiction. Seems like the 10th Circuit was primed to hold that it lacked jurisdiction to review all of this in probably an unpublished decision. But fortunately for Mr. Olmedo Martinez, the Supreme Court published Wilkinson v. Garland a few weeks ago. After that case, quote, application of the exceptional and extremely unusual hardship standard to a given set of facts is reviewable as a question of law under INA Section 242A2D, end quote. The panel recognized that this new rule violated prior 10th Circuit precedent that would have held otherwise, but that 10th Circuit precedent has been vacated. So Mr. Olmedo Martinez survives and gets review. By the way, and this is just me, it's because he was found credible. The facts are not in dispute. But on the merits, the 10th Circuit saw no BIA error. After all, as I and Eddie Ramos and many others lamented almost immediately after Wilkinson, there is some non-citizen, not-so-friendly dicta in that decision, and well, the 10th Circuit latched right on. Quote, the Supreme Court explained that because this mixed question is primarily factual, that review is deferential. End quote. Being so deferential, affirmance of the BIA wasn't so difficult to do to the 10th Circuit. Now sure, because this is a motion to reopen, explained the court, Mr. Olmedo Martinez need only show a, quote, reasonable likelihood that the statutory requirement of exceptional and extremely unusual hardship would be met in reopened proceedings. Not the whole case, just a prima facie showing. But still, this exceptional and extremely unusual hardship is not ordinary separation hardship, explained the 10th Circuit. It's often, but not always, quote, very serious health issues or compelling special needs in school, end quote, for qualifying relatives such as U.S. citizen children, explained the court. Apparently, Mr. Olmedo Martinez's son has a, quote, complex bowel issue, end quote, and is in a, quote, individualized education program, IEP, at school, end quote. But all of this is not enough to the court on deferential motion to reopen review. In fairness, it doesn't seem like Mr. Olmedo Martinez overwhelmed the BIA with hardship evidence, but also, who knows? The BIA reviewed everything cumulatively together, explained the panel, which I suppose would also include the fact that Mr. Olmedo Martinez's brother has a well-founded fear of persecution and will more likely than not be persecuted in Mexico due to a family dispute of which Mr. Olmedo Martinez is part of the same family? Undiscussed here. For what it's worth, the 10th Circuit does make clear that the motion to reopen prima facie standard is, quote, only the reasonable likelihood standard, end quote. So that's a good thing to have in quotations for non-citizens in the 10th Circuit. It was just correctly applied here, said the court, meaning that Mr. Olmedo Martinez did not succeed. And that is Olmedo Martinez v. Garland. Say goodbye to missed calls and wasted time on unqualified consultations. With Staffy Live, you get a dedicated team of truly bilingual and highly empathetic specialists answering the phones for your immigration law firm 24/7. Staffy Live specialists go beyond just answering calls. They qualify callers by asking the right questions, ensuring that only qualified consultations make it into your calendar. Plus, they don't stop there. Staffy Live can also handle follow-ups, so you can focus on what you do best, practicing law. Staffy Live is a service for immigration law firms only. And here's the best part. You can try Staffy Live absolutely free for 15 days, no strings attached. Just visit www.staffy.cc, that's stafi.cc, and click Get Started. Of course, use the code FREE to claim your free trial, or click on the links in the show notes. We all know the immense dedication it takes to be an immigration lawyer. You fight tirelessly for your clients, their families, and their futures, but let's face it, the administrative side of running a practice can feel overwhelming. Mountains of paperwork, endless calls, juggling deadlines, it can easily steal your focus and leave you feeling burnt out. But what if there was a way to simplify all of it? I want to tell you about FileVine, a legal case management platform specifically designed by lawyers for lawyers. FileVine keeps all case information centralized in one place. Plus, FileVine's immigration-specific tool, Immigration AI, uses the most advanced AI-powered technology to extract vital information from passports, birth certificates, and other essential documents, and automates USCIS form filling through smart questionnaires available in up to 170 languages. Pretty impressive. FileVine and Immigration AI can give you back precious time and energy, allowing you to focus on what matters most, your clients and their cases. So if you're ready to reclaim your time and rediscover the joy of practicing immigration law, head on over to immigration.ai/immigration review. Links in the show notes. This podcast is sponsored by Driftwood Capital. Driftwood Capital boasts a 30-plus year track record, transacting on more than $3 billion in hospitality assets. Since 2015, Driftwood Capital has successfully implemented the EB-5 program into their development deals, helping more than 160 families find a secure path to residency through their projects. Driftwood Capital is a vertically integrated commercial real estate firm specializing in hospitality with dedicated acquisitions, development, lending, and management divisions. Their goal is to create long-term partnerships with its network of more than 1,200 active investors from the United States and abroad, while targeting attractive returns. Driftwood's unique approach involves managing all aspects in-house, from developing renowned hotel brands such as Marriott, Hilton, and Hyatt, to managing their portfolio of more than 80 hotels in the United States. If you want to learn more about Driftwood Capital, check out the show notes. And of course, let them know who sent you. Our final case is Bustamante-Leiva v. Garland, published by the Fifth Circuit on April 19th, 2024. This case is about Miss Bustamante-Leiva and her 3 minor children, all asylum seekers from Honduras. And it's a rough one. In immigration court, they asserted a litany of particular social groups as the basis for their fear. Something BIA precedent requires that they do or else lose the opportunity to do so forever. Those proffered groups were 1. Unprotected Honduran women who are viewed as property and subordinate to the male-dominated gangs. 2. Unprotected Honduran women who are unable to protect themselves or their children from Honduran gangs. 3. Honduran women who are involved in religious activities and a church that strives to proselytize and convert teenagers from joining gangs and who are unable to protect themselves or their children from Honduran gangs. And 4. A family that is headed by an unprotected Honduran woman who is unable to protect herself and her family, including children, from the Honduran gangs itself and the children from Honduran gangs. And actually 5, Honduran witnesses to witness Honduran gang violence and threats. This is the particular social group world that asylum law has forced us to live in. The family also brought declarations, fact testimony, fact evidence, and the in-court testimony of 2 experts in support of their case. And, well, putting aside the particular social group issue, which is going to be so important later on as it always is, the facts, the actual facts of what happened without all the made-up legal game of protected grounds, is pretty horrifying. Quote, beginning around 2012, gang members used an empty lot adjacent to the back of Ms. Bustamante-Leiva's home to torture, kill, and bury gang victims. Ms. Bustamante-Leiva stated that the screaming from gang victims was audible in her home and that the smells from the events carried through the walls. Because the family felt unsafe in this neighborhood but lacked the financial resources to leave, Ms. Bustamante-Leiva's husband left the family to earn money in the United States. He made this decision with the goal of earning enough money for the family to move. End quote. But then the gang started targeting the children for recruitment. So Ms. Bustamante-Leiva fled an hour away in Honduras. But now, poor and on the run, Ms. Bustamante-Leiva's eldest son left for the United States to earn something for his mother and siblings. That's what he told her, at least. He was killed in a train accident in Mexico on his way to the United States, surely through some sort of unsafe smuggling. And it turns out that the gangs in Honduras were actually telling him that he had to join or die, which was the main reason for his flight. Ms. Bustamante-Leiva and her remaining children lived in peace in another town for a little while, but the gang came calling in 2015. The gang knew that she was alone and knew that her husband was sending her money from the United States. They told her that they'd kill her children if she didn't pay them, in a pretty gruesome way. In response, Ms. Bustamante-Leiva consulted her pastor, who went to her house to pray with the whole family about it. The gang called during that prayer, and Ms. Bustamante-Leiva put that call on speakerphone for the pastor to hear. The pastor advised that she flee, so she did to another city, but the family member there was so nervous that they told her to leave after a short while. So she came to the United States with her children after being helped by a family member. Quote, after entering the United States, Ms. Bustamante-Leiva learned that the family member who had helped her was killed near his house by gang members for helping the family flee Honduras. End quote. All this was apparently deemed credible by the immigration judge, as was the expert testimony of Ms. Bustamante-Leiva's psychologist and country condition expert. The IJ just didn't believe that what happened to Ms. Bustamante-Leiva was bad enough, or that it happened for the right reasons. The BIA affirmed. As did the Fifth Circuit, pretty much on nexus. The Fifth Circuit, too, doesn't see a valid particular social group. Terrifying or not, what happened to Ms. Bustamante-Leiva was not on account of a cognizable particular social group or other protected ground as asylum and withholding of removal requires, explained the court. A valid particular social group must be immutable, particular, and socially distinct. In the Fifth Circuit, particularity means a lot of things, including that there can't be, quote, reference to the very persecution from which its members flee, end quote. Recent precedent from other circuits rejects such a categorical rule about particularity, but not the Fifth Circuit. Social distinction, in turn, quote, is determined by the extent to which members of a society perceive those with the characteristic in question as members of a social group, end quote. And for reasons unexplained, only 2 of those particular social groups that I read at the top made it to the Fifth Circuit for review. 1, unprotected Honduran women who are unable to protect themselves or their children from Honduran gangs. And 2, a family that is headed by an unprotected Honduran woman who is unable to protect herself and her family, including children, from the Honduran gangs itself and the children from the Honduran gangs. Neither of these groups are socially distinct, said the Fifth Circuit. In Suate Oriana v. Barr from 2020, the Fifth Circuit said as much about the group of, quote, Honduran women who have been targeted for and resisted gang recruitment after the murder of a gang-associated partner, end quote. The Fifth Circuit held in that case that that group lacked the necessary social distinction to qualify as a particular social group. And in the very non-citizen adverse Jacko v. Garland decision from 2021, where the Fifth Circuit essentially said that it would follow matter of AB even if the Department of Justice no longer did, the court rejected the group of, quote, Honduran women who are unable to leave their domestic relationships, end quote. Just a heads up, circuit watchers, if the Fifth Circuit is citing Jacko, the non-citizen's probably in trouble. And with such case law in place, the court saw Ms. Bustamante-Leiva's experts as actually supporting a denial. The country condition expert, for example, conceded that violence against women in Honduras is part of a larger phenomenon of violence in general. The Fifth Circuit saw this and some other evidence as showing that there was nothing distinct about the gender-based claims brought here. To the extent that the proffered groups were changed a bit to avoid all of these bad decisions on appeal to the BIA refused to consider it, and the Fifth Circuit said that that was okay. Nor did the Fifth Circuit see a religion-based claim. Religion, of course, is another protected ground that would avoid any entanglement with these pesky particular social group requirements. But to the Fifth Circuit, quote, the evidence does not compel the conclusion that religion was a central reason for the harm by the gang, end quote. To the court, the involvement of the pastor and religious conviction of Ms. Bustamante-Leiva was tangential to what went down. Having rejected her asylum and withholding claims on the merits, the Fifth Circuit summarily rejected some of Ms. Bustamante-Leiva's collateral procedural challenges. The court rejected her argument that the BIA violated her due process rights by having one member decide her appeal rather than a 3-member panel, as the Fifth Circuit similarly rejected a few weeks ago in Mejia Alvarenga v. Garland. This despite the fact that under the regulations, quote, single-member BIA panels do not have the authority to reverse an immigration judge's decision unless reversal is plainly consistent with and required by an intervening change in law, end quote. So, that means it's probably harder to win your appeal if you don't get a 3-member panel, right? That's the argument, at least. But the Fifth Circuit didn't buy it. Or it said that it was precluded by prior precedent of really even considering it. Nor did the Fifth Circuit believe that the BIA acted impartially, even though DHS never filed a brief, and the BIA apparently decided and raised arguments on DHS's behalf on appeal that it then used to deny that appeal. Quote, there is no authority requiring either party to file briefing before the BIA, and petitioner's argument is otherwise legally insufficient to prove bias, end quote. In any event, reasoned to the Fifth Circuit, Ms. Bustamante-Leiva had not presented evidence of actual bias by anyone at the BIA. Tough decision. Ms. Bustamante-Leiva and her children lost it. And that is Bustamante-Leiva v. Garland. So there you have it. you're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.